Last week, the Ninth Parliament passed the Public Order Management Bill 2011 amid steep-word controversies from the 54 opposition members of Parliament in the House.
I would have a problem with you. You are just a hooligan.
However, this is not the first time a public order bill has been passed in this land. The first public order bill to be legislated was under the Obote I regime, and this was called the Public Order and Security Act 1967. The Public Order and Security Act 1967 was made shortly after the overthrow of the Uganda Independence Constitution of 1962 through violence in 1966.
The UPC government introduced a similar bill, Public Order Management Act. And one of those members, who happened to be my mentor and a friend, known by Grace Ibinjira, enthusiastically embraced that bill.
It was later followed by the imposition of a state of emergency by the central government over one part of the country, Buganda, which lasted until 1971. The Constitution of the Republic of Uganda 1967 that carried a comprehensive Bill of Rights and provisions for imposition of a state of emergency at the same time was to be repped by the enactment of a draconian Public Order and Security Act 1967. The spirit of passing the Public Order and Security Act 1967 was to contain Apollo Milton's central Uganda opponents. However, Professor Kanyahamba says, to the surprise of the framers of this draconian law, they were the first victims when the law started biting hard.
And I asked him about it, and he said, George, he used to call me George, you must be very, very careful in accepting or participating in the enactment positively of a repressive measure, because you never know when that measure will make you a victim.
According to a research study by Professor Kiduma Kubuya, a professor of law, about Obote's Public Order and Security Act 1967, the actions of the implementing officer under the Public Order and Security Act were not subject to review by courts.
The people went to jail as a result of it. 5 ministers were arrested and taken to jail. And when somebody wanted them to be bailed, they took them into northern Uganda, then an emergency, in order to deprive the courts of granting them bail. Terrible.
Under the Public Order and Security Act 1967, both Obote and Amini used unlawful arrest and detention as a key part to their official security policy.
I think if it has been something bad, critical of me, my people will not be happy as now. You understand?
The government as well also relied on provisions in the Emergency Powers Act 1963 to effect endless arrests that were fruitlessly challenged in courts. Still not satisfied with the need to consolidate state power, another draconian law to beef up the Public Order and Security Act 1967, the deportation ordinance was imported from the disbanded colonial rules. The deportation ordinance gave the Uganda government carte and blanche to arrest whomever they wanted.
Any Public Order Act which is enacted to be superimposed on ordinary laws of the country is very dangerous. It is intended to repress the freedoms of the people.
However, in compulsion with the Obote I regime Public Order and Security Act 1967 and the just passed Public Order Management Bill 2011, Professor George William Kanyahamba says this piece of legislation is likely to plunge the country into deeper repression of human rights.
It is much more repressive than the ones that we have had before. Under the similar act of Obote, the officer to invoke the provisions of the Order Act was, I think, a commissioner or somebody higher. The present one has now extended the powers to an ordinary constable.
While the Public Order Management Bill 2011 empowers individual police officers to regulate demonstrations, the opposition in Uganda is not ready to dance to the tunes of the perpetrators.
We shall continue to exercise our rights and to assert them, and we shall eventually win.
Apparently, legal experts question the spirit under which the bill was passed, saying that it contravenes the principle of legal drafting, which demands that a good law must be blind, literally meaning that any legislation should not be made to target a specific audience. Timothy Sbasi, WBS Television, Kampala.